Hello, Chamber family. I'm here today. I'm Isabelle Renault, president of the Chamber. Joining me today is Meg Zabijaka. Meg is a partner with Constangy, Brooks, Smith, and Prophete, and she has been working in labor law on behalf of employers for more than 27 years. And Meg also happens to be the vice chair of the St. Johns County Chamber of Commerce. And I am so excited to have you, Meg, today. We're going to talk about wage and hours and what to expect with the new administration. So let's kick that. Let's get kick started this right now. Talking about something pretty basic when we are an employer is dealing with understanding the difference between a salaried employee versus an hourly employee, as well as exempt versus non-exempt. How do I differentiate all this?
Well, yes, thank you first for having me here today. And that's a great question. Those terms are very often incorrectly interchanged, and they have very different meanings. So when you're talking about an employee being paid salaried or hourly, that is just the way in which they're paid. So a salaried employee would receive an annual salary, usually broken up into certain amounts per month or biweekly. The hourly employee is usually thought of someone who receives overtime, and they're paid based on an hourly rate. But when we talk about exempt and non-exempt, those terms have legal significance under the Federal Fair Labor Standards Act, or what's often called the FLSA. So that's a federal law that governs minimum wage and overtime payment, and that law applies to most, if not all, of chamber businesses. And when you have employees who are non-exempt, they are required to receive minimum wage and overtime payment for any hours worked, generally over 40 in a work week. There are some exemptions. And so if you have an employee who qualifies for an exemption under this federal law, they do not need to be paid overtime. But there are very specific legal tests that have to be met in order to be an exempt employee.
That's
And
right.
if we misclassify an employee as exempt when they really should be non-exempt, there's a risk of the exemption not applying and the company owing back pay and overtime. And go ahead. I was going to say, and with those two classifications for exemptions, there's both a duties and a salary test. So there are very specific requirements that must be met to qualify for that exemption.
So we'll talk about that in a minute. So, but I do like you could very well have a salaried employee that still has to track his or her hours in order to make sure if that person is non-exempt to track overtime, correct?
That is correct. And that's a good point. We often hear employers talk about salaried non-exempt employees. And so while you can have that classification, you can have a non-exempt employee who is paid on a salary. They must still track their hours. They must still be paid overtime unless there are limited exceptions that apply. And I will just say also as an aside, the federal FLSA also has record keeping requirements that apply to both exempt and non-exempt employees. So generally, we don't have our exempt employees clock in and out, but there is nothing wrong with having them track their hours so we know what PTO or paid time off they've used, and we know when they are in the office and not in the office. So there are other reasons you might still keep time records or records of hours worked for your exempt employees, but you're not tracking it like you need to for your non-exempt to make sure we pay them correctly under the
Okay.
FLS.
So one has a legality requirement, the other one is more best practices for the business to still record that. I think there is a lot of confusion sometimes with employers, like, oh, well, my employee is salaried, so I don't have to track the hours. But as you just explained, that is not the case unless they meet certain criteria, which we're going to talk about a little bit in a minute. So let's jump into it. How do I know if my employee, I need to classify that person as exempt or non-exempt under the overtime law? And also remind us that back in July, there was a change in the law. Remind us what that was and how that's affected employers.
Yes. Okay. So let's start with whether someone could qualify for an exemption. As I mentioned, there are two tests. One is a salary test and one is a duties test. So you would need to first meet the salary test, which means the employee is paid currently the limit, which is $684 a week, or an annualized to $35,568. And to be a salaried employee, you also must not make any deductions from that salary I just mentioned for either the quality or quantity of work. So if I work half a day, I'm still going to receive my entire salary for that week. As I mentioned earlier, you might deduct from my PTO balance, but you cannot take my salary amount down below the numbers I just mentioned without risking losing that exemption. And then as it pertains to the salary, I'm sure as everyone remembers, we thought at the end of 2024 and beginning of 2025, we were going to have some significant increases to the salary levels. Those were going to move the salary that I just mentioned to over $800. And then in January, it was going to be moved to over $1,000. And many clients of our firm had already taken steps to increase those salaries in anticipation of what was coming. But lo and behold, in November of 2024, a federal court vacated that proposed rule. And so we are still at this $684 a week and the $35,568 annually. I
So,
will say too, we have several clients who made that move ahead of time and they moved their employee salaries up because they wanted to get ahead of what they knew was coming. This is quite an adjustment, if you can imagine, for employers big and small. And so if there are chamber members who have moved their employees up and then now they knew, or they're just hearing by watching this today, that they didn't need to increase those salaries, you may be able to reduce them back to what the current levels are. It's not going to be the best for employee morale, and there are potential legal implications. So make sure you check with your legal counsel before you do that. But that is something to consider. You also mentioned the duties test, but before I move to that, do you have any other questions before I keep
well,
going?
let's go back to the salary. So 684 or 35,568. So that means that my employee needs to be at that level in order for me to
Classify the employee as exempt, right? And that means that person does not receive overtime pay. They work whatever hours it takes to get the job done. They don't have an entitlement to overtime under the statute.
but they have to meet another requirement outside of the salary. They have to be able to make independent decision, so why don't you cover that portion? That's
Sure.
what they're twofold, right? Salary.
It is twofold.
Yeah.
You have to have both. And the only thing that the law we were all focusing on in 2024 covered was the salary. The duties weren't changing, but you might have heard about white collar exemptions. Those are the most common ones under the FLSA, this federal wage and hour law. There are also some that are exemptions for outside sales employees and computer related professionals. But the big ones are those white collar exemptions for your professional employees who have an advanced degree, perhaps your executive who supervised 2 or more full-time employees. And then the one that we often see is the administrative exemption. And that's someone who must exercise independent judgment and discretion with respect to matters of significance. So this is the most challenging of the exemptions because it is really hard to define what that means. And there are numerous volumes upon volumes of case law trying to determine this. But it really, you look at that individual's duty, and does that individual have discretion to make recommendations, to even make decisions? And those must have significant or substantial weight. So let me just give you a couple of examples. There's some terms that might suggest someone is administratively exempt or not. So if you look at your job description and you have someone described or defined as a helper, an assistant, a coordinator, that over time from our review of the case law may indicate that that person probably doesn't have that discretion that we expect to see for the exemption to apply. On the other hand, if you have things like managing, developing, analyzing, evaluating, deciding, planning, you can see the difference between those words. There's more judgment that's rolled into those tasks than the ones where someone is assisting someone else. I will say it is something that has to be determined and analyzed on a case-by-case basis. Every position stands on its own, and your job descriptions are really important to make sure that they align with what the employee is actually doing. You can have a great job description though, but I'll also say that if the employee isn't actually performing those duties, then the exemption is not going to apply. So both of those things, salary and duties tests, must be met. And it's a good idea to periodically review this to make sure you still qualify.
So let's say if I have an employee that is making more than $35,568 a year, and in addition to that has independence of duty in a sense that they can make analyzing, managing, they can make decisions that are important to the organization, then they will be exempt. So that means I would not have to pay overtime, correct?
Correct. Both of those tests are met. They are, that position is exempt from the overtime requirement.
Okay. Now, if it's an employee that is making the same threshold, 38,568, but then is more of a coordinator, in that case, the employer needs to make sure that the hours is tracked, and not only that, but we need to pay overtime for anything over 40 hours, and that's per week, not per payroll, correct?
That is correct. It is per work week. And the other thing to remember with your non-exempt employees is you may set an hourly rate for those employees, but it's time and a half their what's called their regular rate. So you might pay someone $15 an hour to do a job, but if they receive a bonus or other things that need to be rolled into that rate, their regular rate might be elevated. And that's probably a topic for another day because we could get much into the details there. But that's just one more thing to look out for, is that it's time and a half at what is called their regular rate. And that's another one of those terms that has legal significance.
Like a full compensation then, right? Is that how you
Right.
describe it?
Right. Some of those things can be rolled out, but if you give educational incentives and other types of incentives, there are regulations that say you have to roll those into the rate. So it elevates it essentially to a bit higher than just whatever the hourly rate is for the role.
And Meg, you want to remind us that this rule applies to any employers regardless of size, right?
For the most part, yes. If there are some extremely small employers that don't operate in interstate commerce, but that is the exception to the rule. I would say 9 times out of 10, the majority of your chamber businesses are going to be covered by the federal wage and hour law.
Okay. All right. Well, that was really helpful. I appreciate that. Now, let's talk a little bit about the new administration and what changes you foresee or you expect in the area of employment law and what we need to look out for.
So the easy answer is we expect a lot to change. And in the short time that the new administration has been in effect, we have seen quite a few changes. So let me just give you a few examples. One of the main things is we're already seeing or that the federal agency heads are going to change. So for example, the National Labor Relations Board, or the NLRB, that's the federal agency that oversees union organizing and also even employers who don't have unions. They protect employees who essentially band together to complain about their working conditions. The general counsel of that agency and one of the board members were removed. I will tell you that in the past year or two, that board had issued guidance that affected things like non-compete covenants, non-solicitation agreements, separation agreements. Those guidances that were issued by the NLRB, I would say were maybe not the most employer friendly. And so we expect that some of those guidances may be rolled back or revised as this administration continues the move in the direction that we've seen it moving. Another federal agency that some of the chamber businesses may be familiar with is the Equal Employment Opportunity Commission, or the EEOC. That's the commission employees will go to if they file a charge of discrimination, if they feel that they've been discriminated or retaliated against in their workplace. Similarly, with the NLRB, 2 commissioners and the general counsel with the EEOC were removed from their positions as well. The EEOC very recently in 2024 issued workplace guidance on harassment and what it viewed as harassing conduct. We think that might be revised or rolled back, particularly in the areas of pronoun usage, restroom rules, and gender identity harassment. Some of the members of the chamber may be familiar with the Pregnant Workers Fairness Act that was effective in June of 2023. There were some regulations issued in 2024 that we think might be revised or rolled back as well. So we expect to see more of that as the new administration comes into its own, so to speak. So it's really important for chamber members just to stay abreast of these legal changes because they're happening in real time.
And Meg, you and your team usually provide a lot of information on the website, Constangy Constangy Brooke Smith and Prophete website. And so we can follow up on that by just going there and finding additional information, as you said, as this new employment law era is coming into its own.
Absolutely. That's constangy.com. And there is a section on the website for news and analysis. We also have a blog that members can subscribe to free of charge. And it provides sort of a more lighthearted view of what can be some pretty heavy legal topics that one of our partners provides. So I would encourage members to review that as well.
That is fantastic. Well, we're coming to the end of our chamber conversation. Is there anything, Meg, that you would like to add?
I would just like to thank you for your time and encourage members to stay informed. And if they need assistance, please feel free to reach out to the chamber or their legal counsel to make sure that they get the answers they need as we move forward in what appears to be a bit of an uncertain time. So thank you.
Well, thank you so much, Meg, for joining us again. Meg Zabijaka with Constangy, Bruce Smith, and Prophete, and she's also the vice chair of the chamber. Thank you all for joining us today.
Yeah.
Bye.